Hi, in this segment, I'm going to touch upon the aspect of probate that happens when someone isn't dead. Hi, I'm Deric Rangell. I'm a 30-year specialist of probate sales in Southern California. In this segment, I'm going to touch on conservatorships, particularly why it's important to understand them. And the primary reason is as people my age or younger, but generally as our parents start to age, most people don't think about estate planning when they are at an early symptomatic stage. Let's say, for example, Alzheimer's. But according to Anthem Blue Cross, the average age of a person experiencing symptoms, and they range from mild to severe, but the average age of being detectable is 65 years old. And so this is really important because once we know someone is diagnosed and they're likely to have their mental capacity severely diminished moving forward, the aspect of probate that steps into this space is conservatorships. And the reason why it's important to understand and really have this on your radar, particularly, there's senior specialists in real estate, there's people who are certified in assisting seniors. But one of the things I never see is a conversation about why conservatorships are important to people and what you can do within a conservatorship to establish an estate plan and a trust. And this is really important because what I see, countless times, and it's the norm, is as our parents start to age, our relationship stops going from anything relating to estate planning, and it's understandable when your parents start aging and you see their capacity diminishing, and you're losing the version of them you remember and want to hold on to. What they're also undergoing is a need to start having some decisions get made to position their estate for when they can't make their own decision. And usually when you get to that stage, the majority of people are too late in doing this because you can't go in and get a conservatorship while someone is hanging on to life. You can't have somebody sign documents where they have obvious diminished capacity when someone is hanging on to life. So the reason why you would want to look into at least what you can accomplish by filing a conservatorship on someone's behalf is to get the court's assistance to create an estate plan. Because one of the things that happens often is as seniors, as they start losing their mental faculties and their capacity to understand things starts to diminish, they're prey and they are preyed on. And there's all kinds of laws out there and that will try to protect them. But really, it's the family that really has this land on them. And so a lot of people, to the real estate agents who help clients, to people out there who have parents that are at early stages of Alzheimer's or dementia, things of that nature. If the episodes of the forgetfulness or the lapses that they tend to experience start getting more pronounced, you're going to want to start thinking about this. Specifically, it's Probate Code 2580. Now, in Section 2580 of the Probate Code in California states that the court can have the conservator use substituted judgment to make a will, a trust, or both to make sure the conservatee has an estate plan. The court may also let you use this power to change or revoke a trust, make gifts, change insurance policies or annuities, and sign contracts for a conservatee. So a family member or an interested person, like a family member, could be a friend, could be another attorney, acting in the capacity to serve as a conservatorship. That happens often when family just doesn't want to, but you can still get this done. And that can present a petition asking for substituted judgment. So when you do that, you're sending a copy of your petition and notice of a hearing to the same people you gave notice to for the conservatorship hearing. And you also give notice to the hearings to all beneficiaries in the conservatorship. And you also give notice to the hearing to all beneficiaries in the conservatee's current estate plan and anyone who would inherit from the conservatee under the laws of intestate succession. So basically, the state of California gives you a direct access in the event that your parents didn't do estate planning And there's lots of reasons why people don't. We don't have to go into that now. But if you're one of them, if you're one of those people who has a parent who didn't, and all you're doing is worrying about maintaining their health, which is obviously the number one priority. Number two priority is none of us are living forever. And as we pass our estate onto the generations who succeed us, great thing you can do is not expose your loved ones or any interested parties to a probate. So if you look at, like of late, it's not uncommon to see probate administration expenses top $30,000 for your typical median sales price home in LA Orange County. It's very common. If you're doing this stuff and you have a conservatorship, and during the conservatorship you get a trust set up, you're probably going to spend under $5,000, at which point, if the loved one we care about does pass, by having that plan in place, the only thing you would need to do is to find your successor trustee and have them sign a consent to serve, and then they go ahead and take on and do the trust's business as the court had oversight for. So somebody goes and gets an estate plan, they create a living trust because the person's still alive. The court approves that living trust because it measures up to the standard, and more importantly, it delivers the estate plan protection that a typical living trust ought to. And all that can be handled through the court, so you can get someone's affairs in order. And that's a big deal, because letting it all go and being stuck in conservatorship and then also in a probate, when you have this option available to you, is something that you're going to wish you knew about. So I'm telling you now, this is a smart thing to do, but more importantly, it's something to pay attention to. The people in our lives, our potential clients. If you're out there working in real estate and you're farming and you see that there's elderly people and all of a sudden you see their kids around more and more, do them a service. Talk to them and just inform them that in the event this should happen, if they don't already have a living trust in place, a conservator can actually acquire through that substituted judgment in section 2580 of the California Probate Code. They can take that situation and get a thorough estate plan, and you can thank me later after you have that. So anyways, it's something that with the aging population, we're all going to presently experiencing this now with family members. Probably you know someone too. That's why it's important to talk about this stuff. Nobody likes talking about death before people actually die, but there is the business and the care that is worth doing and doing correctly that will save the estate and maximize the distribution to the beneficiaries. And so that's really what I wanted to touch on. It's an important aspect, and it's more prevalent than most of us would ever understand. I see it because I see the data in the court filings, and there's a lot of them, but a lot of them don't go in and do the substituted judgment, start to create estate planning through that. So if you have that situation, or if you think that situation might be on the horizon, you want to talk about it, my information is on the screen, or you can send me an email. My information is posted. So hopefully this will help somebody out there. And don't forget to like and follow. And if you have any comments that you'd like to make, feel free to. I'd love to address anything on your mind about this. Take care. Be well.